Good morning. Good morning. Good morning.
Good morning, ladies and gentlemen. Thanks for all your assistance.
Good morning.
Good morning.
A very good morning to you, and thank you for joining us for a virtual conversation with the judiciary. Let me make special welcome this morning our Chief Justice, the Honorable Mr. Justice Brian Sykes, the Honorable Mr. Justice Patrick Brooks, President of the Court of Appeal, His Honor Mr. Chester Crooks, Chief Judge of the Parish Courts, Mrs. Tricia Cameron Anglin, Director, Court Administration Division, and Dr. Denarta Dennis, Chief Court Statistician. Thank you to the members of the press who have found it convenient to join us this morning. You are an important stakeholder, and as such, we continue to have dialogue with you in this way. We are this morning hoping to have your feedback, and we will feed your questions on what has been happening in the judiciary. Thank you all so much. I do apologize for the late start that we have had, but as you will understand with these technical setups, sometimes there are challenges and we have to sort those. So special thanks to the team from the Jamaica Information Service for partnering with us and facilitating this morning. Without any further delay, I am going to ask this morning our Chief Court Statistician, Dr. Denarta Dennis, to provide us and provide you with an overview of the statistics on the performance of the courts at all levels. So, Dr. Dennis, you may proceed with your presentation, sir.
Thank you very much, Mrs. Fletcher. Honorable Chief Justice, Mr. Brian Sykes, Justice Brooks, President of the Court of Appeal, Chief Parish Court Judge, His Honor Chester Crooks, Mrs. Cameron Anglin, PEO, colleagues, members of the media, pleasant morning. So this morning, as Mrs. Fletcher mentioned, I am tasked with the responsibility of doing a review of case activity and court productivity, the performance of the court system at all levels so far in 2021. In terms of the structure of my presentation, I will first give a brief overview for purposes of context of the performance of the courts in 2020, very brief overview. Then I will outline, with the aid of graphical tools, how the major business lines in the court system have been performing so far in 2021. The sequence will be Parish Court Criminal, Parish Court Civil, the Supreme Court, and the Court of Appeal. It is, of course, well documented that the Honorable Chief Justice has set out to position the Jamaican court system to become the best in the region and among the best in the world within the next few years. The presentation of the statistics, therefore, must be understood within the context of three major quantitative targets that have been set by the Chief Justice, which must be accomplished in order for the goals mentioned to be realized. And these are the attainment of a court-wide case clearance rate of 130%, the attainment of a court-wide trial date certainty rate of 95%, and the attainment of a net backlog rate, that is the percentage of active cases that are in backlog, of under 5%. So these are three important statistical anchors that have been set by the Chief Justice to guide the performance of the judiciary over the next few years. The Jamaican parish courts, in particular, showed tremendous resilience in 2020, despite a general downturn in overall court activity, and in spite of the continued constraints in 2021, there has been a rebound in total case activity and productivity across most of the business lines in the court system. As I indicated in my structure, I will start by giving a brief overview of some of the key indicators, performance indicators from 2020, before segueing into what has happened so far in 2021. As I indicated, the statistics suggest that despite the downturn in general activity in 2020, the court system demonstrated a significant amount of resilience. So starting at the parish court criminal business line, in 2020, 21,166 new cases were filed. This was a decline of 20.94% when compared to 2019. It took an average of 7 months for criminal cases to be resolved in 2020, and the trial date certainty rate for the criminal division of the parish courts was 74% in 2020. For the civil division of the parish courts, 16,920 new cases were filed in 2020. This was a decline of 26.40% when compared to the previous year. On average, it took roughly 10 months for civil cases to be disposed in the parish courts in 2020. The trial date certainty rate for the civil courts was 81.16%. These statistics must be understood within the context that what is considered an ideal standard in terms of clearance of cases is a rate between 90 and 110% internationally. But as I indicated before, the Chief Justice has set a target for the judiciary as a whole of 130%. And this is because this anchor rate is necessary to reduce the case backlog in the court system to below 5% of active cases. So that's the logic behind the 130% target. So as far as clearance rate is concerned, the criminal division of the parish courts had a clearance rate of roughly 90% in 2020, which means that for every 100 new cases that were filed in 2020, 96 cases were disposed in the criminal division, which under the circumstances is quite a strong performance. The civil division of the parish courts also fared strongly, with a clearance rate of roughly 95%, suggesting that for every 100 new cases that were filed, 95 were disposed. In the Supreme Court, we had 12,757 new cases filed in 2020, which was just 2.74% below the 2019 figure. So there was still strong activity as far as new cases filed in the Supreme Court in 2020. The overall case clearance rate for the divisions of the Supreme Court in 2020 was 66% roughly, which means that for every 100 new cases that were filed, the Supreme Court disposed of 66 cases. Of course, this is below the targets that have been set and below the international standard, but certainly it reflects incremental improvements that have been made over the last few years. For the Supreme Court divisions as a whole, it took an average of just over 2 years for cases that were resolved in 2020 to be disposed. The Court of Appeal registered 221 new appeals in 2020, which was a 19.93% decline when compared to the previous year. The Court of Appeal also recorded a commendable clearance rate of roughly 81% in 2020, which is an improvement over the previous year. In terms of the activity relating to judgments in 2020, the Supreme Court in 2020 had 111 new judgments reserved and 260 judgments delivered, which means that the clearance rate for judgments in 2020 was 234% for the Supreme Court, which is the highest annual rate for the Supreme Court in recorded history. It was 45 percentage points higher than the rate recorded in 2019. The Court of Appeal delivered 170 written judgments in 2020, which is an increase of 37%, 37.10% to be exact, when compared to 2019. So the Court of Appeal also had a significant increase in the number of judgments delivered in 2020. I'll be heading into a quick review of what has happened so far in 2021, but it's important to provide some further context to the structure of the court system. The parish courts as a whole file anywhere between 320 and 400,000 new cases every year on average. The traffic court division of the parish courts account for, by far, the largest share of case activity, with over 70% of new cases filed each year. And they are followed by the criminal division of the parish courts, and then the civil division, and then the family court division of the parish courts. So that's the order in terms of the contribution of each of the major business lines in the parish courts to overall case activity. So traffic accounts for the highest share, followed by the criminal division, followed by the civil division, followed by the family court division in the parish court system. Okay. In the first quarter of 2021, the aggregate number of new cases filed in the criminal division of the parish courts was 7,079. This is up by 16.28% when compared to the first quarter of 2020. The corporate area parish court criminal division, the St. Catherine Parish Court, and the St. James Parish Court accounted for the highest incidence of case activity in the first quarter of this year. Together, the three courts, St. Catherine, St. James, and the corporate area, account for almost 50% of the total number of new cases filed in any given quarter or year. The overall case clearance rate in the first quarter of 2021 for the criminal division of the parish courts was 94.89%. The chart is being displayed right now as to the distribution of clearance rates across the different parish courts criminal division. The overall rate was 94.89% in the first quarter, which was a decrease of 1.58% percentage points when compared to the corresponding quarter in 2020. What this result means, of course, is that for every 100 new cases that were filed in the criminal division of the parish courts, roughly 95 were disposed, which is in line with the international best practices and is an indication of early signs of recovery in total case activity in the parish courts at the beginning of this year. And what we see is that among the courts that performed the very best in the first quarter of 2021 in this business line were Manchester, Portland, and Westmoreland. Interestingly, 10 of the 13 parish courts met the international standard of between 90% and 110% on the case clearance rate for the first quarter of 2021, with 8 of the parish courts exceeding a 100% clearance rate, which suggests that those 8 parish courts would have disposed more cases than the number of new cases that were filed in the quarter, which is a very impressive result. In terms of trial date certainty rate, in the first quarter of 2021, the parish courts as a whole recorded an 81% trial date certainty rate, which is a significant rebound compared to 2020 when a number of trial dates had to be rescheduled. The trial date certainty of 81% in the first quarter of 2021 for the criminal division of the parish courts suggests that for every 10 dates that were set, 81 proceeded on schedule. One of the most interesting findings from the first quarter report is that the criminal division of the parish courts recorded a net case backlog rate of 2.65% in the first quarter of 2021, using the last 4.5 years worth of data as a proxy. And this means that 2 or 3 of every 100 cases filed over the past 4.5 years in the criminal division of the parish courts ended in a state of backlog and were still active. The gross backlog rate over the same period was a notable was notably higher at 12.50%. Parish courts of St. Catherine, St. Mary, and Hanover recorded the lowest net case backlog rate in the first quarter of 2021. Now quickly over to the second quarter of 2021 for the criminal division of the parish courts. The criminal division of the parish courts recorded a case clearance rate of 111.61% in the second quarter of 2021, which is an increase of 60.11 percentage points when compared to the corresponding quarter in 2020, which is of course a clear indication of both increase in total case activity and also an increase in the productivity of the parish courts. As far as performance in the Supreme Court is concerned, well, before I get into the Supreme Court, I want to highlight something very, very important for the parish court system, which is that cases originating over the past 4.5 years, which were disposed, of all the cases which originated in the parish court system for the past 4.5 years, roughly 39% were resolved within 90 days, 60% were resolved within 6 months, and roughly 81% were resolved within a year. Overall, roughly 94% of all cases were resolved within 2 years in the criminal division of the parish courts. In the Supreme Court, what we saw in the Hillary term is that we had 3,306 new cases filed, which is a significant rebound compared to the Hillary term of 2020. The case clearance rate across all the divisions of the Supreme Court in the Hillary term, which is the first term of the year, was 64.82%, which was a slight decrease of 2.69 percentage points when compared to the corresponding period in 2020. And the High Court Division of the Gun Court, the Matrimonial Division, and the Probate or Estate Division of the Supreme Court were the best performing divisions in both the Hillary and Easter terms of 2021, all recording case clearance rates of over 85%, which means that for each of those three divisions, for every 100 new cases that were filed, over 85 cases were disposed, and we're seeing the evidence of it in the chart here for the Easter term statistics. We see the specific rates that were recorded for the different divisions. Of course, there are significant variances across the divisions. So we see where the rates for the Easter term of 2021 would have ranged from a high of 128% for the High Court Division of the Gun Court to a low of 20.07% for the High Court Civil Division. So there are some divisions of the Supreme Court that are performing significantly better than other divisions. As far as the case backlog in the Supreme Court is concerned, as of the Hillary term of 2021, the Supreme Court had a an estimated case backlog rate of 28.10%, which means that roughly 28% of all active cases in the Supreme Court in the Hillary term of 2021 were in a state of backlog. And for clarity, we quantify a case as being in backlog if it is over 2 years old and not disposed. Very importantly, as far as judgments are concerned, in the Hillary term of 2020, in the Hillary and Easter term of 2021, the Supreme Court exceeded 100% clearance rate in terms of judgments delivered. In the Hillary term, the Supreme Court had a clearance rate on judgments of 160%, which means that for every 10 judgments that were reserved, 16 were delivered in the period. In the Easter term, the clearance rate on judgments was 138%, as displayed here in the chart. What that means is that the Supreme Court has been delivering more judgments than the number of judgments being reserved so far in 2021. So the Supreme Court is ahead of, in terms of the pace at which judgments are being delivered, they are ahead of the rate at which judgments are being reserved so far in 2021, which is consistent with the thrust of the Chief Justice to significantly reduce the waiting time between the reservation and delivery of judgments. As far as the Court of Appeal is concerned, so far in 2021, the case clearance rate on appeals recorded so far in 2021 is 51.58%, which means that for every 10 new appeals filed in the Court of Appeal so far in 2021, roughly 5 appeals have been disposed. And which is a preliminary figure. I must point out that the figures on the Court of Appeal are preliminary. As far as applications are concerned, the clearance rate on applications for the Court of Appeal was roughly 63% so far in 2021. And finally, as far as judgments activity is concerned, so far in 2021 for the Court of Appeal, the preliminary clearance rate on judgments so far is over 100%, just as with the Supreme Court. So far this year, the Court of Appeal has been staying ahead of the number of judgments reserved in terms of the rate at which they are delivering judgments. So the overall picture seen here is one in which we're seeing that despite the downturn in 2020, in some business lines, we are seeing that so far this year, most of the business lines and courts are showing significant improvements in overall case activity and also in productivity, which is a good sign for the key quantitative anchors that I mentioned earlier that have been set for the Chief Justice for the courts to become the best in the region and among the best in the world. Thank you.
Thank you very much, Dr. Dennis. And just to remind the members of the press that at the end of the presentations, we will be entertaining questions. So we just ask you to make a note in the meantime. Following Dr. Dennis, we're now going to jump over to the Chief Judge of the Parish Court, His Honor Mr. Chester Crooks, who will bring us brief remarks on what has been happening in the parish courts. Judge Crooks.
Thank you, Madam Moderator, Mrs. Khadij Fletcher. The Honorable Mr. Justice Chief Justice, the Honorable Mr. Justice Brooks, President of the Court of Appeal, Mrs. Trisha Cameron Anglin, Director of the Court Administration Division, the Narto Dennis Court Statistician, members of staff of the Supreme Court, Court of Appeal, and the Court Administration Division, and parish courts island-wide, and members of the media. Good morning. Well, as was borne out by the data that's presented by Dr. Dennis, I think it's very fair to say that the parish courts are the first point of contact for most Jamaicans with matters before the judicial system, if not the only point of contact. Consequently, the parish courts account for the bulk of matters in the judicial system. It is therefore incumbent that we manage these cases to ensure that matters are dealt with in a timely manner. Our time standard, as outlined in the strategic plan, is 24 months. And again, given the data presentation by Dr. Dennis just now, that seems to be a highly realistic standard. In other words, we are aiming to have all matters disposed of within 24 months from point of entry into the parish court. We do this against the backdrop that and understanding that these are not just cases, but also people's lives that have been put on hold, while they await the decisions of the court to move on with their lives. In other words, we fully realize that most persons who come before the parish courts come there not because they necessarily want to, but because they have to. And this is inclusive of complainants, defendants, litigants in the civil realm, traffic court, and the family court, so have you. I also wish to use this opportunity to thank our staff and stakeholders who continue to give yeoman service in order to allow us to dispose of cases within a timely manner. At the parish courts, we believe that we can do better and must do better to create a court system that all Jamaicans can be justly proud of. As a result, at the behest of the Chief Justice, the Differentiated Case Management Committee was formed earlier this year in March, and this committee is tasked with setting time standards for completing various types of cases in keeping with the push towards trial date certainty and effective courtroom utilization. It forms part of the judiciary's wider strategic goals of reducing backlog, eliminating delays and adjournments, among other key objectives as outlined in the strategic plan. The members of the DCM committee are select senior judges of the parish courts, the Chief Justice, the Director of the Court Administration Division, and myself. Differentiated case management is a technique used by courts to tailor the case management process and the allocation of judicial system resources to the needs of individual cases. Thus far, the committee has agreed to 4 case processing categories, namely simple, standard, complex, and highly complex. Shortly after a matter is filed into the court, it will be assigned to the applicable category depending on the nature of the matter. Additionally, each category has a time standard. For the simple cases, we are looking at anywhere from 3 to 6 months. In relation to cases in the standard category, we are suggesting 6 months. For complex cases, we are recommending at least 1 year, and for highly complex cases, a minimum of 2 years. It's important to note, however, that thus far, these categories and time standards are applicable to criminal cases only. The thinking is that as we go along, with a little tweaking, the same principles will be applicable to civil, family, traffic, and other types of matters. We are presently in the process of seeking feedback from all parish court judges and courts island-wide, and will be looking to implement this program within early to mid next year. This promises to be a paradigm shift for the judiciary, and at the parish court level especially, as we want to further enhance the confidence of the public that if a matter ends up in the court, it will be dealt with swiftly, decisively, and with certainty. Members of the public can then be assured that matters will be dealt with in a reasonable time. I'd also like, in keeping with the thrust of effective case and time management, I'd also like to mention the fact that we are looking to modernize and make more efficient certain processes before the parish courts. For instance, application for spirit licenses, and hopefully we can roll this out to other sorts of applications such as club licenses and the like, where we'll have fillable forms that will be available online. This will reduce the need for persons having to come before the court for these processes. This was in train long before the pandemic, but the pandemic now has made it a necessity to be more efficient in terms of how we deal with certain processes, both by way of serving the public efficiently and being overall more efficient in the processes of the courts. I'd also like to take this time, again, the data presented by Dr. Dennis bears this out, that the parish courts have been doing extremely well in terms of managing the matters and disposing of the backlog. We still have a ways to go, but we still strive to do better, and this is notwithstanding the challenges of the pandemic. Let me take a moment to acknowledge the persons we have lost, both at the private bar, and tragically, it culminated in the loss of two of my fellow parish court judges, Mr. Stanley Clark, former senior judge of the Parish Court for St. Anne, and Mr. Horace Mitchell, former judge of the Parish Court for St. Elizabeth. I'd like to take this opportunity to acknowledge the service they all provided, and I'd also like to thank the staff who nonetheless continue to serve the public in very trying times. I'd also like to thank the public for their patience, because sometimes we have some disruption where, subject to the mandates handed out by the government of Jamaica, we might have to restrict our processes, or persons might be inconvenienced in terms of being able to attend court and have their matters dealt with in a timely manner. For the parish courts of Jamaica, we will continually strive to be on our way to becoming the best in the Caribbean in 3 years and one of the best globally in 6 years. Thank you.
Thank you very much, Judge Crooks. We're going to change gears a little bit, and we're going to go over to the Court Administration Division to find out how they have been supporting the administration of justice across the island. So at this time, I'm going to invite Mrs. Trisha Cameron Anglin. She's the Director, Court Administration, to bring us brief remarks.
Thank you, Mrs. Fletcher. I will adopt the protocols already established and just say a very good morning to you, and please accept a very warm welcome. And thank you all for being on the platform this morning as the judiciary marks yet another conversation with the judiciary, the digital edition. And it's very fitting that it should take place this week, which is being observed as National Customer Service Week. And at the Court Administration Division, we provide the administrative support services for the judiciary. And service is one of the cornerstones of a modern judiciary. And so as we celebrate and mark this Customer Service Week, it is fitting that we, as a court system, that we are called to build a system that is courteous, pleasant, customer-obsessed, and focused on treating each person with respect and dignity. And that is basically what it means to provide excellent customer service. We continue to employ a variety of means to which we are empowering our staff who interact with the public daily to raise the levels of service across the courts. We celebrated and continue to celebrate for the remainder of this year under the theme, You, Me, We Got the Power of Service Excellence. And we are reminded as a judiciary that coming to court is not a voluntary experience, and that we start with our customers being unhappy. And so every day we remind our court staff that this is an opportunity, an awesome one, for each court staff to impact the lives of the persons who come to the courts and to make the experience not a burdensome or onerous one. So we are committed to strengthening the capacity of our court staff to provide excellent service. And this we do by continuing to partner with the Heart Trust NSTA for training and certification of our staff. And recently, we have concluded certification exercise for over 100 staff members across the court system as customer service champions. So we should see that reflected in terms of our service delivery across our court system. We wish to continue to celebrate and to affirm our customer service charter, which was established in 2014 and can be found on our website. We continue to utilize our customer service monitoring framework to enhance service delivery, and these are available to our stakeholders and the public. Our customer service complaint system, our customer service telephone and email feedback system, our social media platforms, and our suggestion boxes which are in our courts. We pledge our commitment to providing sound, timely judgments and efficient court services. And we have digitized our brochures to ensure that our public can communicate well and understand our processes and procedures. We are committed to service excellence. Thank you.
Thank you very much, Mrs. Cameron Anglin, Director, Court Administration, giving us that update on service delivery across the courts. Now we're gonna jump over to the President of the Court of Appeal, the Honorable Mr. Justice Brooks. And just before Justice Brooks, just to remind you, we are going to be fielding your questions immediately after the presentation from the Chief Justice. And the Chief Justice's presentation will follow that of Justice Brooks. So, Justice Brooks, over to you, sir.
Thank you very much, Madam Moderator, Mrs. Fletcher. Honorable Chief Justice, ladies and gentlemen, present and viewing online, please allow me to adopt the protocol which has already been established and say greetings to you all. As most of you are aware, the judiciary is an equal arm of the government. It therefore accepts that it is accountable to the people of Jamaica for the exercise of the responsibilities entrusted to it. The Court of Appeal, being the highest court that is based in the island, is mindful of that accountability. As a result, and as an attempt at transparency, the court since 2016, under the initiative of past President Morrison, an annual report on its work. The annual report is sent to the Chief Justice, to the Parliament, and to other stakeholders. The report gives a snapshot of the major aspects of the court's work, and with the assistance of our Chief Statistician, Dr. Dennis, some statistics on the areas which are measurable. Dr. Dennis has already given the major statistics that affect the Court of Appeal, and so I make only brief reference to some of them. The court hears appeals from divisions, all the divisions of the Supreme Court, which Dr. Dennis has earlier mentioned, as well as the Parish Court. In addition to that, we hear appeals from the regulatory bodies such as the General Legal Counsel and the Public Accountancy Board. The appeals are usually heard by a panel of 3 judges. There are some preliminary, or what we call interlocutory matters, which are heard by single judges, and those are usually applications, and those I said are heard by a single judge. So far this year, as Dr. Dennis has said, 221 appeals have been filed with the court. That's the same amount that was filed for the entire year for 2020. And applications and motions so far filed this year total 176. There are 13 judges in the Court of Appeal. We achieved this number, this establishment, just in January of this year. For 50 years prior to 2019, the court was operating with 7 judges as its complement. And that historical situation has been affecting us even now. With the onset of the pandemic, the court has been in a better position than most of the other courts in the island, in that we have been able to shift more easily to hearing our cases online. And the situation, therefore, is that we are using the online platform to hear our cases in the majority of cases. And the situation is that although we have that benefit, which is an advantage over the other courts, the situation is that the technology fails us, and we recognize that we are not in the more than just being basic in terms of the service that we provide online, but we understand that budgetary constraints prevent us. I therefore have to thank the judges and the hardworking staff of the Court of Appeal for continuing to soldier on in this, despite these challenges. We thank also our attorneys at law and other stakeholders who appear on our platforms for their patience, because quite often our systems go down from time to time and we have to be rebooting. We thank the Court Administration Division, the technical staff there, because they continue to assist us to try and bring us back up when the technology fails us. There are three areas of the court's operation that I want to quickly address, because I know the court is aware of the concern of the public in respect of it. And the three areas are the time it takes for the court to receive the record, the time it takes for the appeals to be processed through the court, and the time that it takes to deliver judgments. Now, the time that it takes for the court to receive the records are largely out of the court's hands. We depend on other courts to provide the records. In the terms of the criminal cases, we have a number of outstanding transcripts. We recently started, just this week started, an initiative to look at the very oldest of those cases to determine what is the situation with them, how they can they be resolved. It has been an eye-opening experience, and it may be that the numbers that we have are not as great as they could be, but there are other elements which come into that factor, and those will have to be investigated. As the Chief Court Reporter has started an initiative to increase the level of the transcripts being produced to the court, and that has been bearing results. In terms of the civil cases, we have in the court been speaking to the attorneys at law who represented the various parties in those oldest of cases, and seeking their assistance to try and get them to produce a record between themselves, since we are unable to get it from the Supreme Court. As far as the parish courts are concerned, we are not sure of the number of cases which reside in the parish court, because appeals are filed in the parish courts themselves, and we have to wait until the record comes before we know that appeals exist. In terms of the second item, the time it takes for cases to proceed through the court system, we basically wait until and start measuring from the time that we receive the records or the transcripts. And before the pandemic, it would be on an average about 6 months to have the case from the point of getting the transcript to the point of hearing the appeals. It has been thrown out of whack in terms of the pandemic, but the situation is that where we have uncertainty in respect of getting the records, we pretty much are certain that once a case is set for hearing, for the appeal to be heard, almost 9 out of 10 times it will be heard on the date that it is set. We have to thank the attorneys because they make sure that they make themselves available and make themselves ready for the appeals to go on, because they appreciate that the judges do not have the time to prepare a case more than once. So far this year, as Dr. Dennis has said, we have disposed of 114 appeals compared to 179 for the entire year last year. In terms of item number 3, it takes the time it takes to deliver judgments. As at yesterday, we had 79 reserved judgments, including cases where the decisions have been handed down, but the reasons for the decisions are outstanding. And by now, 5 of those have been delivered. The judges are aware of the dissatisfaction that it takes for the length for appeals to be heard and for the judgments to be delivered. The fact is that the average case doesn't come to the Court of Appeal. It is usually the more complex ones, and so it requires consideration and it requires reading stacks of material to get to the point of understanding and disposing of the case. The target that the court sets itself is 6 months for the disposal of cases from the date of hearing to the date of delivery of the case, of the judgment. And in terms of statistics, of the 187 appeals disposed of last year, 116 were disposed of on the date of the hearing, another 31 within a week of the hearing, and another 29 within 3 months of the hearing. So all told, 187 were delivered within 6 months of the hearing of the appeal. Each litigant is entitled to have reasons for the decision of the court, and so the court provides those reasons in each case, at least in some reform. And the judges work hard at trying to meet that entitlement. The judges work nights, they work weekends, they work public holidays, and a significant portion of their vacations, well-deserved vacations, are spent writing judgments. So we have to pay tribute to the judges of the Court of Appeal for the service that they provide. The revelation of the statistics from last year's performance has showed us that the time that judges spend out of court in terms of not having to actually sit has increased the productivity in terms of the number of judgments. And as one of our initiatives in trying to bring the outstanding cases up to an acceptable level, we are going to be next term, the Hillary term, that is from January to Easter, be sitting in one division only, which will allow judges to have more time out of court to produce their written judgments. In terms of strategies for going forward, the court has implemented a strategy of giving more decisions orally. So on the day of the hearing, or certainly within the week of the hearing, an oral decision will be given, and that will be reduced to writing, either in the terms of an oral judgment, a shorter memorandum of reasons, or a still shorter endorsement. And that will reduce the number of outstanding judgments. We have attempted, as I said before, to increase the number of time, the amount of time that judges spend out of court. And as a third step, we have been increasing the training to judges and judicial clerks who assist the judges in the writing of opinions and the writing of judgments, so as to make them more concise, make them more focused. And With those initiatives, we hope to increase the productivity of the court and to meet the Chief Justice's goal of the productivity of the judiciary overall. Thank you very much.
And even while we're sitting here, the Court of Appeal is sitting and delivering judgments. Thank you so much, sir. Now we're going to go to the Chief Justice, Justice Brian Sykes, and he will give us his address. And then we are going to open the floor for your questions. We thank you again for joining us, and thank you again for your patience. Chief Justice.
Thank you very much. Good morning, Mrs. Jared Fletcher, President of the Court of Appeal, Chief Judge of the Parish Court, our statistician, Dr. Dennis, and Mrs. Tricia Cameron Anglin, the Director, Court Administration, and thanks to the persons who have made this possible, the journalists who are here online, and those who are members of the public who are listening. So welcome to the second conversation with the judiciary. We began this last year as a means of communicating with members of the public and the media about how the courts intend to improve service delivery to all court users, whether they are located within our domestic boundaries or not. As you would have heard from Dr. Dennis, the performance of the courts has been improving over time, and not where we need to be, but there are encouraging signs that we are heading in the correct direction. Because of the many decades of underinvestment and severe issues regarding the productivity of the court, some persons have the expectation that things will be fixed overnight. But it is actually a process by which we get there, where we have to strengthen the leadership capacity of the administrators of the court and those who operate the mechanisms of the court. It also involves judicial training. It also involves a review of the structure of the courts, because what we have found is that the structure of the Supreme Court, for example, makes it difficult to be as efficient as we need to be. And so that process is being undertaken with the assistance of the Ministry of Finance and Planning. And we have gone through several of the registries within the court. So we're not just seeing a review, but also an increase in numbers to improve service delivery to the people of Jamaica. Now, one of the things that we need to point out as well is that until 2019, 2020, the judiciary did not have a strategic plan. Now that plan is in place, and we are giving effect to that plan. And part of the reason for the statistics is to measure how we are performing against that plan. So for example, the plan indicated that for the year 2020, the statistics indicated that our annual clearance rate for the civil side of the parish court was 95.34%. Now, that is ahead of the projected clearance rate that can be found in our plan. The projected clearance rate for year one was 75.98% and 84.76% for year two. So that's ahead of target. So if that is maintained and perhaps improved, it means that on the civil side, the parish courts will be backlog-free in 6 years or less. On the criminal side of the parish courts, last year, the clearance rate was 96.47%. Based upon our strategic plan, the clearance rate for year one was 84.89%, year two, 94.56%, which means, again, that the parish courts of criminal side are ahead of the projected target based upon our strategic plan. So again, on the parish court side, criminal division, it is expected, if present trends continue, those courts will be backlog free in 6 years or less. So that is what is happening there. Now, as far as the Supreme Court is concerned, the clearance rate last year was 65.89%. Where we need to be is 74.35% for year one, 82.95% for year two. So what that clearly means is that the Supreme Court generally is behind where it needs to be. So that needs to be addressed. But before indicating how that will be addressed, it is important to note that within the Supreme Court, just building on what Dr. Dennis has said, 2 divisions or 2 courts are performing at international standard. That's the High Court Division of the Gun Court and also the Revenue Court. The Revenue Court is in fact backlog free. And the High Court Division of the Gun Court has achieved under 10% of the active cases in backlog and under 5% in terms of net backlog. So translation now, what that means is that the High Court Division of the Gun Court is the first court to meet international standards. So that is a very significant development there, and so too the Revenue Court. So what we are talking about then is trending in the right direction. You have heard from the President of the Court of Appeal regarding the work done by the Court of Appeal, and what that shows is that the court there is heading in the right direction. Now, dealing with the question now of how we are going to be improving the performance of the Supreme Court, that is why we have introduced the Family and Estates Division. And what that will do is to have dedicated judges addressing the family cases. In those types of cases, the areas of disputes are usually division of property, custody of children, and maintenance. And those are the typical issues that arise whenever a relationship, whether married or unmarried, breaks down. And so with that kind of dedicated attention, the expectation is that those cases will go through faster, which means that we have space being created in the calendar for other types of cases to be heard. The other thing that we have done is that we have created a team of judges who will be dealing with assessment of damages cases and what we call simple negligence cases. So those judges, it's a 2-year project, so those judges will be focused exclusively on those. And those 2 initiatives are designed to increase the case clearance rate, the hearing date certainty, and reducing the time from filing to final disposition of the cases. We mentioned the review of the structure of the Supreme Court. At the end of that, well, before we get there, let us put some perspective now. What was happening before was that the same members of the registry who went to court would also be the persons who, on their return from court or chambers, doing the registry work in terms of arranging the documents, placing them on files. So what that meant was that when they went off to court, they didn't have many persons doing that kind of necessary activity, and that resulted in delays. So with the review of the structure of the court, what that should mean is that you have persons who will be going to court and chambers, but you will also have sufficient number of persons remaining within the registry to deal with the files, because the file is at the center of all that happens in the court. If the file is not current, the file is not up to date, then really nothing else can happen. And so that is what we have found over the past 3 years that affected significantly the productivity of the court. The other thing that we have done is to increase the number of judicial clerks. There are 42 judges of the Supreme Court, including the Chief Justice and the senior puisne judge. We had 20 judicial clerks up to last year. The number has now been increased to 40, or rather the establishment has been increased to 42. And so the expectation is with one judge and having the own clerk, then productivity should also improve. We have also introduced last year the measure of not sitting on Fridays, and some persons were alarmed as to why the court wouldn't be sitting on Fridays. But they say, but there's a difference between productivity and busyness. Many persons are busy, but they are not productive. And so what we are interested in is productivity. And what the data is telling us is that with the judges not sitting on Fridays and Fridays being available to prepare and deliver judgments, unsurprisingly, the number of judgments has improved. The output of the court has improved. In fact, I think it was some 600 judgments have been delivered between last year and now, something unprecedented in the history of the court. So we have to get out of this idea that being in court every day means that you are being productive. It doesn't mean that. It just means that you are busy and engaging in a lot of activity. And over the years, we have actually found out that it is actually useless activity, unproductive activity. And so the shift now is to productivity. And that is also being reflected in the Court of Appeal with what the President has said, with one division sitting next term. So again, don't get alarmed about that. It is really about increasing productivity, increasing court user satisfaction. We have also introduced a more comprehensive remote hearings guideline that will speak to. It's on the website of the Supreme Court, and that guideline is just what it says, a guideline to indicate to self-represented litigants, to persons who are represented by attorneys at law and attorneys at law, of how they are to prepare to participate in the remote hearing, what they ought to do during the hearing, and what they should do after the hearing. So I urge all persons to have a look at the remote hearings guidelines. Now, the vexed question now of transcripts from the parish courts and from the Supreme Court. We recognize that the non-production of transcripts is far from ideal. In fact, it's a terrible situation to be in. So what have we done to address it? What we did, we launched our project now in respect of the parish courts, and so far we have identified 121 cases in the parish courts where the transcripts are to be produced, and those are being targeted now for the delivery to the Court of Appeal. We also have to look carefully at the use of appropriate technology in the courts, because the system of transcript production in the parish court is really antiquated. It is one in which the judge writes in longhand, and because the judge is trying to go as quickly as possible, the handwriting may not be the most legible. Then, in the event that someone wishes to appeal at the end of the matter, that note made by the judge has to be read by the typist, who then produces a draft, and then that draft is then sent to the judge. By that time, the judge may be transferred to another parish, and the process goes back and forth until the transcript is produced. So this is pointing to the need to have audio recordings in those courts in particular and across the judiciary generally, where the proceedings are at least recorded, and then we have transcriptionists that can then now turn the audio into text. So those are things that we are looking at along with the National Center for State Courts in the United States. And we have a committee chaired by Justice Pusey. This is Justice Leighton Pusey. We're looking at all aspects relating to that for both the Supreme Court and also the parish courts. In respect of transcripts coming from the Supreme Court, again, not the best way that we are producing transcripts, though it is not quite the same as in the parish court where we have court reporters. But again, the methodologies there need to change. And so we're in the process now of changing the methodologies. And also there's a question now of old equipment. The court reporters have the machines that they use, the steno writing machines, that are not just old, but they're really obsolete. Apparently, nobody repairs those things anymore, and no parts can be bought for them. So they are really fit for the museum. But what is needed now is new steno writing machines. Also, they are in need of computers. They got some computers some years ago, while we're grateful to have them. But time has shown that the computers were not as robust as one would like, and they have been malfunctioning, and so the court reporters have been laboring under this disability, which we intend to remedy. We have gotten in some new computers within the last 2 weeks, and now they are going through the process of being labeled and numbered and so on for distribution. We haven't received all the computers that we need, but the expectation is that over time we will have the number of computers and the quality of computers, and also to replace the steno writing machines. So that is where we are with that as far as the Supreme Court is concerned. And then the final thing that I will speak to this morning, not really directly related to the question of the efficiency of the courts, regard to an announcement recently made by the executive regarding the security arrangements for judges. And so the policy, as I understand it, is that you're going to have 2 tiers. Tier 1, we have some judges who will be protected by members of the Jamaica Constabulary Force in terms of providing close protection services, and those are judges of the Supreme Court and judges of the Court of Appeal. Now, looking through the document, there is no mention of the masters, because the document specifically said Chief Justice and puisne judges. So the masters are clearly excluded from that. Then, in fact, to the best of my reading and recollection of the document, they are not even mentioned in Category 2. Category 2 now, we find the judges of the parish courts, most of whom are women, most of whom travel long distances, sometimes as long as 2 hours in the mornings to get to court, and 2 hours in the evening coming from court, traveling along lonely roads. And so my understanding of the policy is that these judges now will not receive automatic protection from the Jamaica Constabulary Force, because the presumption seems to be that they are at low risk. That seems to be the argument. Now, we have grave concerns about that, because in a situation in which the executive says that it is taking active steps to deal with organized crime. And many of the crimes committed by persons involved in organized criminal activity are indeed tried in the parish courts, such as robbery with aggravation, housebreaking, fraud cases, dangerous drug cases, some firearm offenses. So in that context, where there is a bid, it is said, to cripple and to dismantle over 200 gangs, because that is the number that we keep hearing, at least 200 gangs operating in Jamaica, the decision has been taken to remove automatic security from the GSAF to these judges, most of whom are female, most of whom traveling long hours to and from work. So quite a remarkable decision there. And the policy, as I understand it, is that whether security is provided or not for judges of the parish court will be dependent upon a designation by the permanent secretary in the Ministry of National Security, and that in turn is I suppose influenced, and I say influenced deliberately, not determined, influenced by an analysis done by the GSAF. Or the document as outlined does not say that if the GSAF recommends security, the permanent secretary has to accept it. It doesn't say that. So the permanent secretary has a discretion regardless of what the GSAF recommends. Another aspect of it is of concern to us is the recommendation of private security. Security companies from time to time are litigants in the courts. One of the most frequent areas of litigation is whether the particular security officer is an independent contractor or an employee. And we think that this thinking has the potential to undermine the independence of the judiciary, the integrity of the process. What if security services are contracted from Company A and there is litigation involving Company A, might not necessarily be listed as Company A, but somebody connected to Company A in another part of the island, and a decision is made, one way or the other. Let's suppose it's made in favor of the company. Would it be unreasonable for persons to seek to make the link between using private security companies and the decision that the judge has made? So we think that as far as the judges of the parish court are concerned, they should be granted automatic security from the GSAF. The thinking also is that if you have private security, they can be made special district constables. And even though the policy doesn't say so, but the obvious rationale, what is one of the obvious rationale, is powers of arrest. Because if you have private security persons now, they do not have the power of arrest. They're just like any other citizen and can only act if the crime is being committed in their presence and they observe it, whereas the police officer can act upon reasonable suspicion. In terms of judges having to leave a court, and some of the courts are in remote locations, some are in not so safe locations, such as the Parish Court in Spanish Town. If the judge has to leave there, now with private security, and it may involve traffic management issues, no private citizen can come out and, that is lawfully, that is, stop traffic. Only the GSAF and police officers have that authority. What support will the private security persons have in terms of, in the event of distress, they do not have the resources of the GSCF to call on. What is going to be the situation then? We hope that anything doesn't happen. So we think that that policy is ill-conceived and really should be revised as far as the judges of the parish court are concerned. So those are my remarks. Thank you.
Thank you very much, Chief Justice. And now that completes the addresses from the members of the panel. And so we're going to open the floor now to the members of the media who are on the Zoom platform to pose their questions. The first person to ask their question is Mrs. Dion Jackson-Miller from TVJ. Mrs. Jackson-Miller, can you hear me?
I can, thank you.
Okay, go ahead. Who's your question for, ma'am?
Thank you so much. I actually have 4. I don't know what you would prefer. If you would prefer me to ask them one.
We'll take 2 and then come back around to you, ma'am.
Thank you so much. Lords, my lady, good morning. First, let me follow up on the final point that the Chief Justice just made, if I could. I'm curious as to whether there had been any consultation with the bench prior to the announcement of that particular initiative in relation to the private security officers and the various tiers. And related to that, if there is currently any negotiations ongoing. So that's one. The second question I'd asked at this time has to do with the use of the internet to share some of the proceedings of the court. I notice, of course, with appreciation that the court has been moving in that direction. We saw the recent reading of the indictments and the opening of the ongoing gang case and some judgments handed down. But of course, we'd always love more. So I'm trying to find out what's the thinking of the court in terms of moving in that direction. So it's as a matter of course, rather than an exception as it now is. Thank you.
Very much. Well, in terms of consultation, there was some initial dialogue concerning this, and the dialogue arose in the context where not all judicial officers had close protection officers provided by the GSCF. So it was in that context that there was a difficulty in filling out the numbers required for the judicial officers, both at the Supreme Court, to a lesser extent the Court of Appeal, and also for the judges of the Parish Court. So it was in that context that we knew that the police were having some difficulties there in terms of numbers. And so we're aware of those challenges, but in terms of any roundtable discussion to discuss all the implications of it, then no, there wasn't that kind of discussion. In terms of now the use of the internet to gain greater access to the court is something that we have been thinking about for some time, and it raises the question of open justice. And open justice traditionally meant persons being able to come onto the court building. Literally, if you're walking on King Street and you wanted to see what was happening in the court, you should be able to come onto the court building. But with increasing concerns about security, there's been some difficulty as far as that is concerned. So we have to be rethinking now, what does open justice look like in the 21st century, and what that can mean, having broadcasts via the internet to the members of the public. So it is in that vein that we had the reading of the indictment and the opening statement by the prosecution in a case recently. And what we hope to do is to have more of that, because we also see it as an opportunity to educate members of the public about what actually happens in court. Now, some courts, perhaps the Court of Appeal, or it is easier to do that because you are dealing with largely a transcript. In trial courts, you have the sensitive issue of witnesses may be reluctant to have their voice being broadcast. Persons may may be able to recognize their voices and so on. But even within that, I think in some cases, we still can have some aspects of it being broadcast, and what we intend to do is, as we go along, increase access to what is happening in the courts by means of the internet and other means of communication.
Thank you very much, Chief Justice. Mr. Barrett from the Gleaner. Laverne Barrett from the Gleaner. Yes, go ahead, sir.
Good morning. Good morning. Thanks very much, Mrs. Fletcher. Good morning to you, Chief Justice. My question is really to the Chief Justice. Recently, the Commissioner of Police highlighted 16 cases that were disposed of in the courts this year alone. And in all 16 cases, gun-related cases, the sentences were either a fine, a suspended sentence, or probation.
Yes.
The issue of light sentencing, or so-called perceived light sentences, the commissioner said then, is one that is it emboldens criminal in a society where the use of the gun is so prevalent. I wondered, Chief Justice, what is your response to those concerns? And secondly, has the judiciary conducted an audit of sentences imposed for gun cases over a specific period of time? And if so, what has that audit found?
Well, to the second question, in terms of the audit, no, we have not done so. Now, when it comes to the question of sentencing, it is always the most challenging part of any trial judge's adjudication. Why? Because the law is that the court must endeavor to deal with the individual before the court. So that is why, for example, mandatory death penalty for murder ran into constitutional difficulties, because what the Privy Council was saying is that the circumstances of the individual in which a murder took place is not standard, and so you can't have, or you ought not to have, a situation in which the individual circumstances of the offender has no significant bearing and weight. So when it comes to sentencing, the judge has to balance a number of factors which are set out in the sentencing guidelines, which are on the website of the Supreme Court, the Parish Court, and I think the Court of Appeal as well. And when you read through that document, and I encourage you to read through it, you will see where the committee that expressed in the guidelines that the judge has to weigh, for example, the severity. Well, let's back up a bit. The judge has to look at not just the fact of the offense being committed, but the circumstances under which it was committed. The circumstances of the particular individual who committed the offense, whether there were aggravating features. So you can have, for example, the sentence might vary according to the type of gun. So it might be a .22, for example, as distinct from an AK-47. So in all of that, the judge has to arrive at a balance, and one of the factors taken into account is the prospect of rehabilitation, so that sentencing is not only about retribution and punishment. It is also about the prospects of rehabilitation. Even though it is not mandated by law, but certainly by practice now, I can't think of anybody who is sentenced in Jamaica without a social inquiry report. And that forms part of the consideration of the judge. So the judge has to weigh all of those factors and arrive at what the judge thinks is the appropriate sentence for that particular individual in the particular circumstances of that case. So what does that mean? It necessarily means that you're going to have variations in sentencing, and you're going to have different outcomes. So you can have persons, well, this is a very real case. There's a gentleman who was held up by criminals, shot, and left partially paralyzed. His bodily functions had to be taken care of by his family. So he got information that the criminals were coming back to finish the job. So he got himself a firearm. The police found out about it, and when they went to him, he said, "Officer, I really true you're talking, I may have the gun." And he explained the circumstances under which he got the firearm. Now, the question that would arise then is, should that person be sent to prison for 15 years? And he pleaded guilty too. So should he be sent to prison for 15 years? Is he likely to reoffend? Is that person a risk to the society? So all of those are things that the judge must look at when dealing with any particular case. And so you will always have those variations. It's the same way you have murder, for example. You have different ways in which the murder took place. You have manslaughter. Again, you can have manslaughter arising from a fight, pushing and shoving, and somebody fell and hit the head. It can go right up to somebody speeding through a crowded street. You can have somebody who was provoked and they stabbed the individual and the person died. So in all crimes, you're going to have a wide variety of circumstances and wide variety of individuals who come before the court, and the responsibility of the judge is to weigh all the factors and then arrive at the decision. And so the truth is, you'll always have disagreements. And so that is the system that we have, and that is how it has to operate. Now, if the executive is of the view that the sentences handed down by the trial court judges are too lenient, then they have the option of providing the prosecution with a right of appeal against unduly lenient sentences. In fact, Jamaica must be one of the few countries left in the region, or some would say in the civilized world, where the prosecution does not have a right of appeal in some circumstances. So that is really the remedy. Give the prosecution the right of appeal so it can go to the Court of Appeal, where it can be reviewed. That has existed in the UK now for the better part of 30 years. So that's really the solution. And so the judges have to be independent and impartial and not act according to the dictates and wishes of members of the executive, but apply legal principles to the facts and circumstances before the court.
Thank you very much, Chief Justice. Does any other member of the panel wish to weigh in on that matter? Justice Brooks, go ahead, sir.
That the court, the judges of the Supreme Court, the Court of Appeal, and the Parish Court went through and established a court sentencing guidelines, which the Chief Justice mentioned. And that helps to guide judges in ascertaining what is the correct sentence for the particular individual. And as the Chief Justice has mentioned, where you have a plea of guilt as opposed to a person who has gone through a full trial, then that will make a distinction in terms of where the sentence goes. Also to be taken into account when you have matters of sentencing, whether it is by way of a guilty plea or by way of a trial, you will have situations where the person has not been on bail prior to the conviction, and sometimes for lengthy periods. And that period that has been spent incarcerated, waiting on the trial to be completed or the matter to be brought to completion, that sentence, that portion of incarceration has to be taken into account in the judge's reckoning. Where there is going to be a sentence, then it is usually deducted from the sentence. And where it is that the sentence would not normally be longer than the period that has already been spent, then the judge has other options in terms of probation or otherwise.
Thank you very much, Justice Brooks. Go ahead,
Add
Judge.
there is that before the legislation so stated, the judiciary had the practice of applying a discount to persons who pleaded guilty. But that principle now has now been enshrined in law in the Criminal Justice Administration Act, where it says the person may get a discount up to 50% depending on the stage in the proceedings that they have pleaded guilty, so that the legislature, or shall I say the executive and the parliament, adopted a principle reflected in the legislation that should encourage persons to plead guilty at the earliest opportunity. And when that happens, then the principle indicates that it should result in a lesser sentence, or a sentence that is significantly less when compared to what would have been the sentence had the matter gone to trial. And so if that is the policy that the executive introduced and the parliament enacted and the judges are acting on it, then it's a bit difficult to understand why persons are upset about it.
Thank you very much, Chief Justice. Mr. Earl Moxham is the next person from Radio Jamaica News. Mr. Moxham, you may go ahead, sir.
Good morning, and thank you, Madam Moderator, and good morning to the panel. Two questions I'd love to ask. The first one, in respect of improvements being made to the system and the capacity for delivery of justice, I think there was one element that was left out, and that has to do with the physical infrastructure, the state of the courthouses. I know that there are jurisdictional issues where that is concerned, who is responsible for what, and while there have been improvements, I know that there is still a significant deficit. What's happening, for example, with the situation in Manchester, the use of a makeshift facility following what happened with the courthouse in Mandeville, for example. So I'd like to get an update on that to the extent that that can be addressed. And I'd also like to follow up quickly on the concern raised by the Chief Justice in respect of the provision of security for judges and the particular concern in respect of the Parish Court Judges. Chief Justice, you did say that there was some initial discussion, but following the airing of this concern today, which obviously is a very grave matter, will there be specific attempts at dialogue with the executive on this matter?
Well,
All right, Chief Justice, I'll allow Mrs. Cameron Anglin to go first, sir, and then we'll take the second question. So Mrs. Cameron Anglin, you will address the first question in terms of our physical infrastructure, and then we'll take the Chief Justice.
Thank you, Kadesh, and thank you, Mr. Moxham, for that question. We continue to work with the Ministry of Justice. You did cite jurisdictional issues. And of course, the Ministry of Justice has a responsibility for the building of courts across the island, while the Court Administration Division would have the responsibility of maintaining and managing the court infrastructure. In particular, as it relates to Manchester, the court which was burnt out is now being reconfigured. It has been rebuilt and is to open shortly as a new family court. And ground has been broken for the new courthouse to be built in Manchester for some time in the future. So I believe that the minister, you will hear announcements from the minister and the permanent secretary in short order concerning the opening of the new parish court for Manchester. As it relates to the infrastructure of the courts island-wide, generally you would appreciate that some of these buildings are heritage sites, they are old derelict buildings, so we have been trying to configure the courts to treat with access to justice issues to ensure that our staff, they are safe, especially during this pandemic where we can, and we have been working with the ministry to make the situation as comfortable and as easier for our staff and our stakeholders and the public as best as we can. We are to embark on a program to improve for persons with disabilities as well across the courts, and we have started that, and we will share more on that as we have come to complete that program. So that is what I can say for now on the matter of the state of our court buildings.
Mrs. Cameron Anglin, just before we move on from you, just for the benefit of the persons who are online, can you just shed some more light on the differentiation or the demarcation between the Court Administration Division and the Ministry of Justice?
Very well. The Court Administration Division is a division of the Supreme Court that provides administrative support services for the judiciary in the form of our HR, building and property management, client services and communications, legal support services, the finance management and accounting services. And so we're not a division of the Ministry of Justice, but we are a division of the Supreme Court that provides the administrative assistance and support for the judiciary. Now, the Ministry of Justice, we have a necessary link and relationship with the Ministry of Justice. The Ministry of Justice is responsible for providing capital works for the courts, and in particular, the building of courthouses and the provision of vehicles for the judges under the new legislation, the amendment to the Supreme Court Amendment Act of 2016.
All right, thank you very much, Mrs. Cameron Anglin. So the Ministry of Justice will build the buildings, the Court Administration Division will maintain the buildings. Thank you, ma'am. Chief Justice, we'll ask you now, sir, to address the second question from Mr. Maxam in terms of the security for judges.
Thank you very much, Mrs. Jared Fletcher. But going back a bit to the first question in terms of the buildings, the no new court building in terms of purpose-built courthouses have been built anywhere in Jamaica, I think, for the last 20 years. Many of our court buildings, especially those with the outstations, are either on top of police stations, which are, as you know, many of our police stations are also old. And so the truth of the matter is that the stock of court buildings generally is quite old. I know that there has been talk about building court complexes, but to date, we haven't been able to have any of those complexes started, to say nothing of completed. So when that will happen, we are not quite sure. And in some of the towns, for example, Manchester, but for the fire that happened there, the court quite likely would still have been there. Land has been acquired for at least 2+ years now for a new set of courthouses to be built. But the process is we now know is quite a long one. So that is the difficulty that we are having there. Now, as far as the security of the judges now, it extends further. Whenever I travel around the courthouses and you speak with the staff, their constant concern and anxiety is security. Especially before the pandemic, when you had night courts and the courts were slated to go from 5 until 9. What that meant was that when the regular court finished at 4 or 4:30, and the police who would be there during the day, because the police who are there during the day are just regular police officers who come because of the cases that they have. And so when those police officers leave, there was really no security at all on the courts, except for the judge who may have a close protection officer. So that is what is happening there. So you have judges in the parish court now who don't have close protection and some who have. So the implication of the policy, if I understand it correctly, is that those who don't have now won't be getting any. And those who have now, it will be taken away. Why? Because judges of the parish court do not fall within the category that they are granted close protection by the JCF automatically. It is now going to be subject to an threat assessment done by the JCF and a recommendation made, so that if the permanent secretary says no, based upon what I have read, then that's seems to be the end of the matter. As far as the private security, potential for private security is concerned, will these persons be vetted? I hope so. Who is going to vet them? Because the policy suggests that the engagement of private security may very well be the responsibility of CAD, maybe. So who is going to vet these persons? What if they decide not to turn up to work? The only remedy they have is a contractual remedy, you know what, sue them for non-performance. So who's going to provide the security at that point if the private person decides, for whatever reason, I can't turn up this morning? What happens then? So this concern is not just academic, it has real and practical significance for courts that sit in camera, such as the family courts. The private person who comes here will be subject to confidentiality agreements not to disclose the nature of the proceedings and what happens there. So a lot of things will have to be thought through, but as I said, the policy as outlined doesn't seem to have addressed itself to these things. It seems to be dedicated more to the effort to get more police officers onto the road or actively investigating crime, as it is said, as distinct from the security of the judges, particularly at the parish court level, and of course, the masters of the Supreme Court, who, as I said, were not even regarded as judicial officers according to the policy. They are not mentioned at all.
All right, thank you very much, Chief Justice. I'm going to come back around now to Mrs. Dion Jackson-Miller. We'll take your two additional questions now, ma'am. Mrs. Jackson-Miller?
Thank you so much.
Okay, go ahead.
Thank you so much. One of my questions had to do with after the Noel Chambers case, the judiciary had convened a committee led by Justice Georgia Fraser, which put out a number of recommendations in terms of dealing with persons before the court who are mentally ill, including the recommendation to establish a mental health court. I'm wondering if you can, I'm asking for an update on those recommendations, whether there's been any kind of movement or progress with them at all. That's one. My second question has to do with the concerns that have been raised about sentencing for the non-wearing of masks under the DRMA. And yes, I did read the statement that the judiciary put out in the wake of that controversy. I'm asking though, whether given the very broad ambit that there currently exists because of the way in which that particular bit of law developed and the fact that, as you pointed out, the ceiling is so high, would it be useful to have sentencing guidelines in relation to that issue? Because defense counsel have expressed concern at the great disparity, even taking into account difference in circumstances that you see in terms of the fines imposed. And if I could just add, not really a question, more a suggestion, perhaps Justice Crooks, I don't know if this is something that's being thought of as you seek to improve the issue of transcripts from the parish courts, but I had been wondering if having judges, instead of writing notes longhand, type those notes directly into a laptop might not significantly speed up the process, even as you await a more permanent solution. Thank you.
report, sir? From the mental health report.
Yes, in respect of the mental health report, now nothing much has happened since then, and recent unfortunate events, I think, have brought it to the fore. Unfortunately, we had the demise of a police officer in, is it Linstead or Bogwalk? Because it is said that we had 2 lives lost there, really. The police officer, as well as the gentleman who is said to be mentally ill. And again, it really highlights the need for moving in the direction of a mental health court. And that is one of the reasons why we made the recommendations. And the policy initiative on that now would need to come from the Ministry of Justice. We have documented what the current state of the law is and looked at best practices and so on, and made the recommendation, but nothing has happened in that regard as far as mental health courts are concerned. The judges are still operating within the framework as it existed then and still exists now, unfortunately.
For clarity, sir, you are saying that this requires legislative changes?
It would require legislative changes, yes.
Okay. Judge Crooks, do you want to take the question concerning sentencing under the DRMA?
Or read the disparity in the sentencing for DRMA offenses. Again, you have to realize that we have to work, we are creatures of statutes who have to work within that ambit. I do note the concern about the disparity in sentencing from parish to parish, highlighting St. Thomas as a recent example, but this is something we also need to acknowledge. From parish to parish, the situations are different. Some parishes, the compliance with the DRMA is higher than others. St. Thomas, for instance, has had a particular challenge there. Now, what happened in St. Thomas the other day, the record was not entirely accurate, and there's another challenge we have to face where we are sometimes at the mercy of social media reporters, and of course, usually is a sensational account that gets more likes and views. But I'm going to tell you this. Well, CAD corrected the record, but the next day, based on reports we got, the next day, there was not one person in St. Thomas walking around without a mask. And the persons who are coming out and saying, boy, harsh, the fines are too high for, and so on, they are missing the point. I have had to shame persons who come in front of me into compliance because I tell them, one, persons are losing their income left, right, and center because of the fallout from the COVID pandemic. And every Jamaican who wears a mask, for instance, is not about, it's just a mask. Why are you finding them so high? You are literally, apart from saving your own life, you are saving the life of another Jamaican. So well-meaning persons or social justice warriors on social media, they have to make the point that wearing the mask is more about whether you're wearing a mask or not. It's your responsibility, your own personal feelings on freedom and constitutional rights aside. So, the disparity, as I said, and I can tell you, the judges have been understanding and lenient. I would say I tend to be one of the more lenient judges, but I have noticed what is happening at halfway tree, for instance, notwithstanding the leniency. Because remember, sentences also have to have a deterrent factor, notwithstanding the leniency, and speaking to them and trying to shame them into compliance. The numbers are just increasing. For instance, the persons who hold the parties, they tend to be fined heavier because they are encouraging breaches of the DRMA Act. Again, sometimes we have this thing we call judicial knowledge, where you literally have to know what goes on the street. In other words, you don't operate in a vacuum or a bubble. But some persons now were told that party goers are actually factoring in the cost of the fines into keeping parties because they have to eat a food or earn a living.
All right.
So a message has to be sent, and I think, again, the reporting in St. Thomas was not entirely accurate, but the message was sent and received.
Thank you so much, Judge Crooks. Chief Justice, would you like to weigh in, sir, on whether or not we will consider sentencing guidelines under or for offenses under the DRMA?
Well, the thing is this. The legislature and the executive have indicated by having this wide range of fines that the wearing of masks and other related offenses are to be taken seriously. So they see it as a serious problem. That is why the legislation was put in place to encourage compliance, and where there's non-compliance, you have enforcement. Now, anecdotally, what we have heard is that once the fines in St. Thomas were publicized, the police superintendent is saying that he observed that compliance rates increased, and that is part of the sentencing, so to deter people from breaking the law. When you have, if the sentences are quote unquote light, and you may have repeat offenders, repeat offenses, and so this is what, again, the judge has to take into account what is happening in their particular parish and use that now to take into account what sentence is appropriate to be imposed. The question of sentencing guidelines for that, I suppose persons are saying if for first offense, what the fine should be, well, judges already take that into account. And I suppose if persons are sufficiently disgruntled, then there will be appeals, and then the Court of Appeal now will be indicating the appropriate approach to sentences under the DRMA Act.
Thank you very much, sir.
Sentencing guidelines that are in place are based on the experience of judges and the decisions, the various decisions of the Court of Appeal and other courts over the course of a number of years. We are in very early days in respect of the DRMA and the experience that we have is not yet sufficient to identify where would be the appropriate point for sentencing. And sentencing in respect of fines is going to vary according to a number of factors, including the attitude of the individual when accosted by the security forces, the attitude in court, and a number of other factors which come into play in respect of that particular individual.
Thank you very much, President Brooks. Judge Crooks, I'm going to come back to you and ask you to respond to the issue of judges typing in court rather than taking longhand.
Well, I fully agree that especially, well, in the year 2021, that would be more efficient. As a matter of fact, I have basically given my own self a mandate that I'm going to learn to type, because I'm quite frankly tired of writing long, and I take very good notes, but as the chief said earlier, sometimes my handwriting is so bad, the faster I write, not even I can recognize my own handwriting. I know the CAD has been looking into it, and there's a move afoot to implement, voice-to-text software, which, I mean, even the average smartphone has that, so it's the rule that within the court subject to the needs of the various infrastructure island-wide. But I do agree that we need to utilize the technology. We have recognized that need long before the pandemic, but the pandemic, of course, has actually made it an absolute necessity, and of course, it will make us more efficient going forward. So I concede on that point.
All right. I trust Mrs. Jackson-Miller that we would have taken care of all parts of your question. Alicia Dunkley from the Jamaica Observer.
Good morning. Thank
Good
you.
morning.
One of my questions, or the substantive question I had, has been addressed, but I wanted to know, this might perhaps be more the purview of the Justice Ministry, but the Chief Justice might have an opinion. The CPFSA has expressed frustration with the pace at which cases involving children who are abused sexually and otherwise have moved through the courts. And one of the things that they mooted was the establishment of a court established or dedicated solely to children, similar to that which is in Trinidad and Tobago. I was wondering whether or not the Chief Justice might have an opinion on that. I heard him mention that a team of judges have been assigned to deal with family court matters, I believe, if I heard correctly. Is this a recommendation that could be taken on board?
Well, there are two things there. When we talk about children and being involved with the law, it has two dimensions to it. They can come involved with the law where there's a breakdown of the family, and so that would now be within the purview of the family courts, where the emphasis of the family court is on diagnosis and restoration. So that is the approach that they take. And when you're dealing with children who may need counseling and so on now, it takes a bit of time. It is not simply a matter of dealing with them in the way that you would deal with a defendant who is an adult defendant who is charged with a criminal offense. There are children that have special needs, and the court has to be sensitive to that. So while you want to get through the cases quickly, but you still have to ensure that the court has sufficient time to do its job. You have children who come in contact with the law now from the other standpoint, where they may be coming as victims of crime. In those circumstances, tend to pose a lot of challenges for the court, especially when they are very young. Sometimes they need extensive counseling before they can get to the point where they are ready to participate in proceedings. And counseling sometimes is expensive, sometimes it is not always consistently provided, and that accounts for the delay, because if they have been the victims of crime, then it is more often than not a traumatic experience for them. And some children respond very, very badly to it. And so the court has to be mindful of that and provide sufficient time and opportunity for the children to get to the point where they can become meaningful participants in the process. Then you have other instances where children now are defendants in the court. And again, the question of legal representation now looms large. The question of if they are going to be on bail, where they are going to be unmonitored. And so as that process is going along where there are defendants, there may even be need for counseling and supervision while that process is going on. So we tend to treat children, cases involving children, a bit differently and more sensitively. Much more resources are needed to support that. We're even thinking now, well, not thinking now, but some have even suggested that when you have children whether as witnesses or defendants, there should even be a redesigning of the court rooms so that they are more conducive to creating an environment that is conducive to the child participating effectively in the process. And the current arrangement where the judge is high up on the bench, some distance away from it, and it is more of an authoritarian structure in the court. So a lot of thinking has to go into cases involving children. That is one of the reasons behind the family court and the children's court. We're trying to get the children, those who are defendants, out of the regular court system unless they are charged with adults, into the children's courts, where while the facilities there are not the best, but it's a step in the right direction. But they do pose challenges to the court system, when it comes to giving evidence. Sometimes because you have to have the presence of the police officers, the court reporters, the judge. Some are very reluctant to speak. So it's a whole lot of challenges there.
All right, thank you, Chief Justice. I have a question here from the chat. Tanisha Mundell from the Gleno. I hope I got that right. What considerations are being made for convicts who have appealed but whose sentences have expired while they are awaiting transcripts? Yes.
Well, what I do know is that the Court of Appeal has found innovative ways consistent with the law of dealing with those kinds of circumstances. I mean, it's an unfortunate situation, and again, it comes back to the question of transcript production, which really has to be addressed using appropriate technology. We spoke about the difficulties that the court reporters have, but in addition to that, the court reporters themselves too have to improve their level of efficiency and proficiency. They have the human component in that regard, as well as the technology that is needed, because it is true that a person should have their appeal heard in the shortest possible time, especially if they have been given a custodial sentence.
Justice Brooks, you'd like to add?
There are actually a number of ways which they have been addressed. Usually, or in some cases, what the persons incarcerated do is that when they are approaching their early release date, they apply to the court to abandon the appeal. And so what will occur is that although technically speaking they would not have actually started serving the sentence until the appeal is determined, and that included the abandonment, what the court has been doing is that if they abandon the appeal, then it will take the fact that they have served a certain period of time in incarceration and allow that period to be calculated as part of their sentence. So the sentencing would start from the date when they originally were sentenced, so they would be able to take advantage of the early release date. One other method is if the person was entitled to be granted bail, then if they don't wish to abandon the appeal, then they'll be granted bail to be able to pursue their appeal. There are some cases where they were not entitled to be granted bail pending appeal for a number of reasons which are engrossed in the statute. But in such cases, we ask for the appeal to be brought on regardless of whether the transcript has been produced or not. And recently, in just July of this year, we had such a case. And in that case, the sentence was quashed. It is not always necessarily that will be the result, but we try to find a way to bring the appeal to an end.
Thank you very much, Justice Brooks. Ms. Dunkley, we will seek to get you some data on the matters that are before the Children's Court and how quickly those move through the system. Mr. Barrett and Mr. Moxham, I am coming back to you in a moment, but just to follow up, and those will be the last questions we're taking, just to follow up on that question before Chief Justice, will more court reporters be employed to assist the process?
The question of employing court reporters is a vexed one, meaning the discipline of court reporting doesn't seem to be proving very attractive to many of the people in Jamaica. I do not know whether they don't know about it. Maybe we have to have targeted recruiting as distinct from just inviting persons to apply to be trained. So that is the difficulty that we're having. So even though the course is available, there have not been many persons who have been willing to take up the arduous task of being trained for approximately 2 years to be a court reporter. So maybe the question of publicizing the course and recruiting persons specifically, from perhaps out of high school, that would have to be employed, but to have to find other ways and means of attracting persons to the profession.
Okay, thank you so much, sir. So this is the order in which we're going to close this section. Laverne Barrett from The Gleaner, Mrs. Jackson Miller from TVJ, and Mr. Moxham from Radio Jamaica. So Mr. Barrett, you can go ahead.
Thanks again. Thanks again, Mrs. Fletcher. This question is for the President of the Court of Appeal. And let me say at the outset that I acknowledge that I'm walking a very fine line, given the fact that my question is related to a case recently decided by the court. And it has to do with the ruling that the long wait for transcript amounts to a constitutional breach. I wondered, Mr. President, what time frame is considered to be? What time frame would the court consider to be in breach of the Constitution?
That is going to vary from case to case, and it's going to be very difficult to give you absolute time. But there are certain cases where it is going to be obvious that it's just too long to be waiting, and that's the best that I can give you in these circumstances.
Thank you, Justice Brooks. Mrs. Jackson Miller, I'm told you have a follow-up question. We'll take you now.
Thank you so much. Going back to the issue of the fines for just a moment,
Please mute
the
Mr. Barrett
the legislature has actually indicated its intention in relation to the level of the fines with the development of a schedule to the DRMA, albeit I hasten to acknowledge that this has not yet been published. But it states that not wearing a mask would be a Tier 2 offense, which would attract a fine of $5,000. Again, I know it's not in effect, but would it not be at least reasonable to expect the parish judges to take that into consideration in relation to the intention of the legislature when imposing the fines? And wouldn't you acknowledge that a disparity of $5,000 to $200,000 is much too wide and not justifiable?
The standpoint that it is not yet in effect. So when it is not yet in effect, then the judges have to go with what the law is at the time when the matter is before the court. So that is really the short answer there. If you intend to have lower level of fines, then you change the law. But you can't blame the judge for enforcing the law.
Might I add to that? When it was being considered in terms of the tier of offenses and the relevant fines, I think something was published, but then we realized at the parish court level very quickly that it wasn't enforced. However, it was a sort of guide for us. And again, I will use my own personal example because, quite frankly, it pains me, and this, when I say me, just assume I'm speaking for most of my colleagues, to be imposing relatively, high fines for offenses that you can easily not commit. Ironically, I remember when this was coming, I think from a security standpoint, I think the JCF and actually personnel in the court, at least judges, we had a concern about Jamaicans wearing masks, the implications of crime fighting, but I think we didn't take into account human nature and just how stubborn we are as a people. I do take the point that the fines are high, but going back to my own personal experience, on average, I would charge persons $5,000 for not wearing a mask. I have had repeat offenders for not wearing a mask. And sometimes they come back now, breach of the curfew, and more often than not, the breach of the curfew are coming from a party. And, or even in the no movement days, or fair enough, an emergency arises, you go on the road. And I'm highlighting these instances because, as the chief and the president said, situations are unique, and judges do take that into account. Persons moving around and no movement is because of an emergency. They go on the road, so they already know they're in breach of the law. And what do? They go on the road in breach of the law without a mask. So when the police draw down on them and ask them why they're on the road, they give this reason, but they're already flouting the law, and that's a part of the problem. We keep disregarding the small laws, and it escalates into the bigger laws. We can all work with what we have. When it's published and it's the law, we'll abide by it. But until then, the law, the maximum fines for these offenses is $1 million. If we give the maximum discount, it's a half of that. I won't try to calculate it now because I did law to avoid mathematics.
Right. Thank you very much, Judge Crooks. Mr. Moxham, we're going to come to you now, sir.
Thank you very much. This is a follow-up to the second question that I had asked, and the Chief Justice had responded, but I wanted a more direct answer to my question. The effect of what the Chief Justice has said here this morning about the potential danger posed to judges who are not provided in the future with protection from members of the JCF. The effect of the statement would be a public lobbying of the executive on the matter. But I'm asking specifically whether there will be at least an attempt at specific dialogue with the Ministry of National Security or any other agent of the executive to have this matter addressed centrally.
Short answer is yes.
Okay. I just had to persist. Is a journalist in me.
That's okay.
All right, thank you so much, Mr. Moxham. Now we're going to take some closing remarks. Just to clarify something, Chief Justice, when we say best in 3, best in 6, when does best in 3 begin? Or when did it begin?
Oh, it began in 2019.
Best in 3 began in 2019, so we're in 2020. So that means we are looking at 2022.
Yes.
Okay, so 2022 for best in 3, and then you can calculate from there best in 6. I avoided math too. Another thing to clarify for the persons who are online, how can we guarantee that attorneys' fees do not come from criminal proceeds?
Well, I don't know if you can guarantee that, because when the attorney is being paid, I don't know if the attorney necessarily knows the source of funds. It's a very difficult question.
And the follow-up on that in the chat is, can the court guarantee that fines are also not paid from proceeds of crime?
No, we can't guarantee that. Either the fine is imposed, and once a person turns up with the money to pay, then I suspect that the fines will be collected. We wouldn't be asking the questions as to how, where, and by what means he got it. We have to investigate all of that, because the person may be in custody, because usually when the fine is imposed, unless it is paid immediately, the person will oftentimes be in custody. And so if the person has presented themselves, which on the face of it is legal tender, then to impose that other burden on him at that point would be a bit difficult to enforce and to manage.
Thank you very much, Chief Justice. Dr. Taylor, I do not understand the last part of your question concerning legal aid for all. Do not understand that part. Just to get some closing remarks, Dr. Dennis, are the courts on track for this strategic plan to deliver best in 3, best in 6 in terms of our major business lines?
Certainly, the criminal division of the parish courts and the civil division of the parish courts, which outside of traffic account for the largest share of case activity in the parish courts, those 2 divisions are certainly on track to meet the targets, the quantitative targets set out in the strategic plan. And for the Supreme Court, there's still some way to go. The current trend suggests that some of the targets for the Supreme Court might be missed. But as the Chief Justice outlined, several interventions are being pursued to try and accelerate the process. Within the Supreme Court, though, there are variations. So there are particular divisions in the Supreme Court, such as the High Court division of the Gun Court, which has actually already met the key quantitative targets set out in the strategic plan, as well as the revenue division, as the chief would have mentioned. And the estate and matrimonial division are also very well poised to meet those targets. The main concern lies with the High Court Civil Division and the circuit courts, in as far as attaining the targets is concerned.
Thank you very much, Dr. Dennis. Mrs. Cameron Anglin, from the CAD perspective, how or what will we be doing in the next few months to look at our service delivery in the courts and also in terms of infrastructure, ma'am?
We continue to monitor our service delivery against our customer service charter. We continue to use technology, and our staff across the island are committed to giving good quality service, and we expect that our customers will hold us to that standard and continue to remind us where we are falling short so we can correct and amend and give the service that the Jamaican people need and require from us.
Thank you very much, ma'am. Judge Crooks, any update on the use of technology in the parish courts, quickly, sir, for remote hearings?
Yes, well, I said that is in train and it's subject to the existing infrastructure, so we're working very closely with the court administration in that aspect, as well as we're taking our lead from the project that's being implemented as we speak at the Supreme Court. The thinking is in the hopefully short term to have all the courts island-wide interlinked so that information can be shared in real time to make us more efficient overall.
President Brooks, any closing remarks, anything from the Court of Appeal, sir?
The court, judges and the staff of the court recognize that we are not where we want to be. We, however, it's not a matter of want of effort, but we need to adjust our approach, and that is what we are doing by increments in order to reach the goal that has been set for us as a judiciary.
Thank you very much, Mr. President. Chief Justice, a quick plug for the JCMS, sir, and then our overall commitment to the people of Jamaica for the service that the court and the service delivery that the court provides.
The court, it is a co-equal arm of government and is responsible for the delivery of legal services and adjudication of matters. And we are committed to providing a first-class legal system, notwithstanding the constraints, using data to drive decisions and policies within the courts. And part of that involves the implementation and the introduction of a new case management system, the JCMS, and that is supposed to improve our records management, and it is expected to be a web-based system which would enhance the transmission of information between courts across the island and will enable us to have better quality data which we'll be using to manage the processes of the court in order to improve our service delivery and to meet the time standards that we have set for ourselves. We're aware that in quite a number of cases, persons have been waiting a long time for matters to be heard, and that is why we have put in the provisions that we have regarding the Family and Estates Division, regarding the fast tracking of assessment of damages and cases, and also the simple negligence cases. This is part of an ongoing process of differentiated case management. We heard His Honor Mr. Crooks speak about that in relation to the parish courts, but there's actually a concept that is applicable to all courts. And so during the rest of this year and next year, we will be introducing it more into the Supreme Court, and eventually where we will be getting to is that the different types of cases that come into the Supreme Court will be managed appropriately, giving the right amount of resources, so that at the end of the day, the objective is this: the simpler cases, the shorter cases go through faster, and the more complex cases take longer, not eternally now, but take longer and be completed within 24 months.
Thank you very much, Chief Justice. Well, all that is left for me to do is to thank you all for joining us this morning. continue to dialogue with us. We will continue to open the lines of communication so we can have dialogue in this kind of way. You may understand that judicial calendar doesn't always allow for one-on-one interviews, and so we thought it best to have you all come in this type of way so we could field your questions. So we thank you so much for joining us this morning. Thank you very much to the members of the panel for fielding the questions, and also to the members of the press. We wish for you a productive day, and we continue to reiterate that you, members of the press, are an important stakeholder for us, and we continue to partner with you as we chart the way forward for the judiciary, as we open the lines of communications and inform the people of Jamaica that the judiciary is open for justice. Thank you all so much. Have a productive day.